Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, characterization, tracing, and commingling. Let's begin. California community property essays are won or lost on characterization. Before dividing anything, decide what it is: community property, separate property, quasi-community property, or a mixed asset. The core rule is simple. Property acquired during marriage while domiciled in California is presumed community property, while property owned before marriage or acquired during marriage by gift, bequest, devise, or descent is separate property. But the exam rarely gives simple facts. It gives commingled accounts, down payments from separate funds, mortgage payments during marriage, stock options, businesses, and transmutations. Your job is to build a timeline and trace the money. Identify date of marriage, date of separation, source of acquisition, form of title, payment history, and any written agreements. Then apply presumptions and rebuttals. California Family Code provisions matter. The community property presumption appears in Family Code Section 760. Separate property is defined in Sections 770 and 771. Transmutations require an express written declaration under Section 852. Equal division at divorce generally follows Section 2550. Community property, except as otherwise provided by statute, all property, real or personal, wherever located, acquired by a married person during marriage while domiciled in California is community property. Earnings during marriage are community property. Separate property. A spouse's separate property includes property owned before marriage, property acquired during marriage by gift, bequest, devise, or descent, and rents, issues, and profits of separate property. Earnings and accumulations after the date of separation are separate property. See FAM. Code Sections 770 and 771. Date of separation. Separation requires a complete and final break in the marital relationship, shown by one spouse expressing intent to end the marriage and conduct consistent with that intent. After separation, earnings are separate. Quasi-community property. Property acquired while domiciled elsewhere that would have been community property if acquired while domiciled in California is treated like community property for division at divorce and certain death issues. Transmutation. Spouses may change the character of property by agreement, but after 1980, for a transmutation of real or personal property generally must be in writing with an express declaration made, joined in, consented to, or accepted by the adversely affected spouse. See FAM. Code Section 852. Casual statements or ambiguous notes are not enough. Characterization method. Identify the asset. Identify when it was acquired. Identify the source of funds or labor used to acquire it. Apply the applicable presumption. Consider whether the presumption is rebutted by tracing, title rules, or agreement. Classify as community, separate, quasi-community, or mixed. State the consequence at divorce or death. Tracing method. Identify the separate property source. Follow it into the disputed asset. Show that separate funds were available at the time of acquisition or payment. Account for community deposits and withdrawals. Choose the tracing method supported by facts. Commingling method. State that commingling does not automatically destroy separate character. Explain that the spouse claiming separate property bears the burden of tracing. If records permit tracing, allocate accordingly. If tracing fails, the asset is treated as community to the extent character cannot be proven. Commingled bank accounts are a favorite exam device. A spouse deposits premarital savings into an account, then deposits salary during marriage, then uses the account to buy stock or make a down payment. Because salary during marriage is community property, the account contains both separate and community funds. The spouse claiming a separate property interest must trace. Direct tracing. The spouse proves that separate funds were available and intended to be used for the acquisition. This requires records showing the account balance, deposits, withdrawals, and the purpose of payment. For example, if a spouse deposited inherited funds into a joint account and 3 days later used the same amount for a down payment, with records showing no intervening depletion and intent to use the inheritance, direct tracing may succeed. Exhaustion method. If the spouse can show that community funds had been exhausted when the asset was acquired, then the remaining funds used for acquisition may be separate. This method is fact-intensive and depends on account records. Note: courts do not require separate property to be kept in a separate account, but the spouse who commingles takes the evidentiary risk. Poor records usually hurt the spouse claiming separate property. Property bought on credit during marriage is characterized by the lender's intent and the source of repayment. If the lender relied primarily on community credit, the asset is community. If the lender relied primarily on a spouse's separate property, the asset may be separate. Later payments can create mixed interests. Mortgages create common mixed assets. If one spouse owns a house before marriage, the house starts as separate property. If community earnings later pay principal on the mortgage during marriage, the community acquires a pro tanto interest in the property, often calculated under the Moore/Marsden approach. Community payments toward interest, taxes, and insurance generally do not create ownership in the same way because they are treated as expenses of use or carrying costs, though reimbursement issues may arise. Acquisition versus payment. Character is generally fixed at acquisition, but later community or separate contributions may create reimbursement rights or apportionment. Source versus title. Source of funds usually drives characterization. Title may create presumptions, especially with jointly titled property at divorce, but always discuss both if facts mention both. Commingling versus transmutation. Commingling mixes funds and creates tracing problems. Transmutation changes legal character and requires an express written declaration. Gift versus convenience title. Putting a spouse's name on title may suggest a gift or trigger statutory presumptions, but the analysis depends on timing, type of property, and divorce versus creditor or death context. Earnings during marriage versus earnings after separation. The date of separation cuts off the community's interest in later earnings. Always mark it on your timeline. Forgetting the burden. The spouse claiming separate property from a commingled account must trace. Treating interest mortgage payments as equity contributions. Principal reduction is the key payment for ownership apportionment. Ignoring gifts and inheritances. These are separate even if acquired during marriage, unless transmuted or commingled beyond tracing. Finding transmutation from affectionate language. An express written declaration must show a change in ownership character. Dividing before characterizing. Classification must come first. Assume wife had premarital savings. During marriage, she deposited those savings and her salary into one account. She used the account for family expenses and later bought a rental property. Start with the community presumption, because acquisition occurred during marriage. Wife can rebut only by tracing separate funds. If records show inherited or premarital funds were available and used for the down payment, the rental may be mixed. If records are incomplete, the untraced portion is community. If the rental was purchased with a loan, discuss lender intent. If the lender relied on both spouses' earnings, the credit is likely community. If the lender relied on wife's separate collateral, that supports separate characterization. Then track repayments. If wife later wrote, "I want husband to feel this is our home," that is probably not a transmutation. If she signed a deed or written agreement expressly stating she changes her separate property into community property, Section 852 may be satisfied. The exam rewards careful statutory language and a clean timeline. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.